umaga sa lahat. I'm Dr. Cortez, your business doctor. Welcome sa subject natin today, obligation and contracts. So we are now in lesson number 8, nature of contracts. Once again, I'm your business doctor, giving you lessons on business management, marketing, finance, taxation, and entrepreneurship. But before I continue, may request to click the subscribe button. Salamat sa suporta. Alright, so let's start with lesson natin. I will give you first the objectives, the learning outcomes of our topic for today about contracts, kontrata. So today, ito yung ating mga outcomes. Explain what a contract is and essential elements that make up a valid contract, such as offer, acceptance, consideration, mutual consent, and legal capacity. And recognize and categorize different types of contracts. Maraming klase ng kontrata, no? It can be in business, management, personal, selling insurance, yan. And the third one, understand the specific roles and activities involved in each stage of the contract or life of the contract. And lastly, identify characteristics that make a contract enforceable. So ito yung mga objectives at the end of the lesson. Ito yung mga things that you should be capable of doing or achieving. And after the outcomes, ito yung ating mga topics, agenda for lesson number 8. Definitions of contracts, common examples of contracts, stages in the life of a contract, characteristics of a contract. And disclaimer once again, I am not a lawyer, so I'm not qualified to teach law subject, but I'm just sharing to you guys yung mga nababasa ko sa mga books and in the course of my lessons in other subjects. Okay, so start natin. So ating subject na tinuturo or sinishare ko sa inyo is obligations and contract. So we are done with obligations. We are now in the second part of yung ating topic, that is contract. And let us read this one. A contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So meeting of minds, at least shall be consent. Mutual consent na may bibigay yung isa. Not necessarily written. We don't have the word written sa ating contracts. Basta meeting of mind that binds himself to the other person. Pwede kang magbigay, pwede kang gumawa, or you can render some service to the other persons. So at least two persons, no? So pwede may third party, third person sa isang kontrata, but the minimum, there should be two persons involved. So it means we can't have a contract kung mag-isa ka lang. So after the definition, go to an example of contracts. So maybe you are still a student, you don't have yet some experience or sample in being involved in a contract, but later on, whether personal, at work, or in your business, you can be involved in some kind of a contract. The first one is the employment contract. Maybe for majority of you, this will be your first experience in being a party in a contract. Pag magtatrabaho ka na, you will be employed. So, companies or majority of the companies, all of the companies will give a contract. Being an employee, the company of, and for them being the employer for you. Anyway, an agreement, employment contract is an agreement between an employer and an employee. So, employer-employee relationship. Outlining the terms of employment, including job responsibilities, salary, benefits, and working hours. Okay, if I can recall the first time that I was employed was maybe 1992. That was, is it 22 years ago? Or 32 years ago? Yes, started 32 years ago. The first time that I was employed in one fast food chain in the country. Actually, multinational fast food chain in the country. As a part-time employee, they gave me a contract. Nakalagay doon kung ilang buwan. And that time, if I can recall, that was only for 6 months. So nakalagay yung duration, 6 months. Magkano yung per hour, if I can recall, parang 20 pesos lang per hour yung sahod dati. Per oras, no? In a part-time. Ano yung mga responsibilities ko? Benefits, I can't recall kung marang benefits, no? But we were given a discount card na magagamit namin sa mga branches ng fast food. At kung ilang oras. So, minimum was 4 hours per day. Now, later, if you will be working in one company, so nakalagay dun sa mga kontrata nyo, magkano yung pwede sa per oras. No? Example, if you're already academe, yung sweldo per oras, example, 800 per hour, 1,000 per hour, nakalagay sa kontrata. At kung ilang months, example, per semestral ang kontrata sa mga universities. Mga private companies naman, it can be a 3-month contract, magkano yung sahod. Yan. And what will happen if you have violations committed? And if you have benefits, nakalagay sa employment contract between you and the company. So that is an employee-employee relationship. Number 2, lease agreement. A contract between a landlord and a tenant specifying the terms under which the tenant can occupy a property, such as a rent amount, duration, and maintenance responsibilities. Ang lease agreement, that is long term. Example, you will be leasing a building, an apartment for 10 years, 5 years. Mas mahaba yan. Pag sinabi kasi ng rent, pwede isang buwan lang per month, no? Pag-renta. Pero pag lease, mas mahaba. Pwedeng throughout the lifetime of the property. Pwede mo siyang i-lease. Kano per month. What will happen if you have violations? Meron bang down payment? Meron bang advance payment? Example, 3 months advance, 3 months deposit. And number 3, the sales contract. One good example, yung selling something or selling a vehicle, the deed of sale, yun yung buyer and seller, magkano, yan, down payment ba? 50%. And the balance payable in how many months? Like 6 months payable yung balance. Or pwede siyang bagsakan. No? And the fourth one, the service agreement. It happens sa mga, I have, for this sample, what I had was number 1, number 3, and number 4. From service agreement, I have experienced this one. In one of the universities, I was employed as a regular employee. In fact, a college dean in one university. Then, pag mayroon mga seminar akong attendan, example, a 2-day seminar, and then the company, the university will pay for me the seminar fee, the board and lodging, the transportation. So, they will spend for me. Example, I attended the seminar in Clarkfield, Pampanga in 2018. So, the university shouldered all my expenses. Ayan. Example, in all, that was 10,000. A 2-day seminar in Clarkfield, Pampanga. So, they spent for me. So, anong kapalit? So, yan ang service agreement. So, ang service agreement, they will shoulder the fee, but I should stay in the company for 2 years after the seminar. So, di pa pwedeng umalis. So, pag marami kang seminars in 1 year, so, ano yun? Bawat amount, example, 6,000, meron sa corresponding amount kung ilang years ang stay mo sa company. And in the same university, it happens also in private companies, no? Hindi lang sa mga university. If the company will shoulder your seminar fee or accommodation or abroad or local, you have to stay in the company for a specified period of time. And also, one time, when I was doing my doctoral, so the university shouldered expenses. So I was a scholar in the university. Kaya lang pag-graduate noon, hindi ako pwedeng umalis university. Kasi may babayaran akong service agreement. Yan. So medyo matagal, no? Like 2 years, 3 years. Yan mga sample ng mga service agreement sa mga private companies. I don't think the government, how do they do this one? But This is goings on when it comes to private practices. Okay, and the next one. Next slide. Stages in the life of a contract. Basahin natin yung kanyang definition. The preparation stage of a contract. Itawag din natin itong pre-contract stage. Anong kasama dyan? It involves the planning. Bago magpirmahan, nag-uusap muna, no? Yung dalawang parties. Before the formal contract is drafted and signed, pinag-usapan muna kung anong ilalagay sa kontrata. This stage is crucial for setting clear expectations and establishing. So, importance nito, hindi pwedeng sulatin kagad yung kontrata. Baka mabulaga or ma-surprise mga party. So, pinag-usapan muna, no? When it comes to amount, duration, time, year. Example, yung mga player ng mga basketball players, no? Mga boxers. So, maraming matagal yung negotiation. Matagal yung preparation, conception stage before the formal signing of a contract. Nagkakasundo minsan no? Siyempre may kanya-kanya mga interest bawat party. So those should be put in the contract. Pag-usapan. Bago ilagay sa contract. Kasi pag hindi, i-revise yung kontrata. No? Pag may pasinulat hindi na pag-usapan sa preparation, revision ng contract. Although madali naman yan kasi nakafile naman sa mga Word format yan, di ba? Pero yung effort, yung time, medyo matagal yan. So, conception stage is important. And second one, stage in the life of a contract. Ito yung perfection, pag-execute ng contract. The perfection stage of a contract, also known as the formation or conclusion stage, is when the contract is formally created and becomes legally binding. It occurs when the offer made by one party is accepted by the other party and all the essential elements of the contract are present. This stage marks the point when obligations and rights are clearly defined. Sabi ko kanina, hindi naman necessary na nakasulat ang kontrata. Basta merong meeting of minds. Yung kanina, pinag-usapan kung ano yung dapat ilagay or agreed upon sa number 2. Magkakasundo na sila dito. Yan, nakasulat. Pag if there is in writing, nakasulat na yung mga provisions or stipulations, mga clauses sa kontrata. Yan. Kumbaga, yung pinag-usapan sa number 1, sinusulat na sa number 2. And the last stage. So we have 3 stages, no? Sa life ng kontrata. The consummation or execution. So basahin natin siya. The consummation stage of a contract, also known as the execution or fulfillment stage, occurs when the obligations outlined in the contract have been fully performed by both parties. Sa kontrata, may mga obligation yung both parties. Yan. Naka-outline na doon and they will now execute or fulfill or perform yung mga napagkasunduan or stipulated. This is the final stage in the life of a contract. Both parties fulfill their respective duties or obligations as specified in the contract. Number 1, pinag-usapan pa lang kung ano ilalagay. Number 2, sinulat na. Number 3, they will now fulfill yung both obligations of the parties. For example, one party delivers the goods or services. The other pays the agreed prices. So, mutual. Yung delivery or fulfillment ng mga obligations nila, dito na yung gagawin sa ating number 3. They will now execute kung ano naman ang pagkasunduan na nakasulat sa number 3. Okay, so preparation, perfection, consummation. Those 3 stages of the life of a contract. Okay, so ito yung tatlong yung pagdadaanan if you have contract, employment, personal, or business, or pag-render ng service. Okay, and let's go to the next one, the characteristics of contracts. We have 5: obligatory, mutuality, autonomy, relativity, and consensuality. So majority of the contract ay may mga ganitong mga characteristics. Let us discuss yung first one, obligatory. From the word obligation, from the word obligatory, no, parang you are obliged to fulfill, both parties are obliged to fulfill yung kanilang mga respective obligation stipulated upon sa kontrata. Number 1, obligatory force characteristic of contracts. It refers to the binding nature of contracts. Ang isang kontrata, binding. Okay, nagkasundo, that is binding, meeting of minds or written. So both parties, they have the legal duty to fulfill the obligations outlined. Asulas, ang kontrata medyo maraming pages to, no? It is numbered. Bawat paragraph can be an obligation, naka-outline siya. So this principle is central to contract law and ensures that once a valid contract is made or signed by both parties are now legally compelled to follow or to fulfill yung mga obligations na nakalagay doon. Pag yung kontrata daw is formed, it is now the obligations of both parties to fulfill the respective. Pwedeng isa may bibenta, pwedeng isa may babayaran. Ibig sabihin nito, both parties are now legally bound to perform anong promise niya under the terms of the kontrata, no? Kaya kanya-kanyang promise yan. Now, pag sinabing obligatory, the contract is now legally enforceable. Sabihin, pag isang party nag-default or hindi siya fail to meet the obligations, yung isang party, pwedeng yung buyer, pwedeng yung seller, he has the right to seek enforcement of the contract. Pwede siyang pumunta sa korte or in a legal means, no, to file a case against the other party. That is legally enforceable. Ibig sabihin yan, the contract is now legally enforceable. Pag nag-fail ka, pag meron kang default, pagbayaran, pagbentahan ng sasakyan, for example, yung isa hindi nag-deliver, isa hindi nagbayad, so either party can go to the court and file in a legal means. Ayan. So pag wala, pag may nanalo, one party can ask for damages or compensated for damages for a specific performance or termination of the kontrata. Yan ang pwede mong remedy, no? Pag yung isang party in default, can go to the court, ask the court for compensation or damages, or pwedeng specific performance, delivery pa rin ng sasakyan, for example, or pwedeng termination of contracts. Diba? Yan mga pwede mong remedy pag number 1, characteristic. Then the second characteristic of a contract, that is mutuality. The word mutual. The mutuality characteristic of a contract, it refers to the principle that a contract now is based on mutual agreement, meeting of minds or written between the two parties, the obligor or the obligee. So sa number 2 natin, it highlights the reciprocal nature of a valid contract. Both parties must have agreed to the terms and must be bound by the contract for it to be enforceable. Masabi natin kanina sa number 1, stages, merong preparation, yung conception stage, pinag-usapan natin, no? Kung anong di-deliver ng isa. Ibig sabihin yan, bago isulat yung mga pagkasunod sa number 1, pinag-usapan muna and you have meeting of minds kung ano ba yung ilalagay doon. So it means mutuality, mutual, reciprocal. Parang nagkasundo yung dalawang parties, kaya tinabag natin siyang mutuality. And the third one, autonomy. The autonomy characteristic of contract, also known as autonomy of will or freedom. Yung both parties, autonomous, ibig sabihin they have the freedom. Freedom to contract, freedom to be involved in a contract, freedom to sign a contract. Ibig sabihin yan, it allows the parties to have the freedom to negotiate. Pa ikaw yung isang party sa kontrata, you have the autonomy. Autonomy for what? To negotiate, enter into a contract, and set the terms of their agreements. Yan. So pwede kayo you have the freedom to set agreements. Example, magkano bayaran, magkano presyo, magkano interest. ilang beses installment, saan babayaran, ilang down payment. Kasi ayun basta you have the freedom as long as that is within the bound of the law. Within the legal, legal parameters pa rin ng batas natin. Hindi ka pwedeng lumampas doon. You have the freedom but within the law itself. That is what we call the autonomy. Additionally, this characteristic grants individuals, lahat kayo na who enter in contract, you were granted, pwedeng individual, pwedeng entity, kasi an individual can enter into a contract. Also, a business, an organization, an entity can also enter into a contract. So pag sinabing autonomy, what individuals, organizations, or entities are given the independence to create your own obligations according to your preference. Okay? Example, pag pinag-usapan natin employment contract, di ba? Yung company, it has the freedom kung magkano ibibigay na sweldo. Yung isa namang party, the employee, he has the freedom to negotiate, accept, or reject yung stipulated. So you can negotiate kung ano yung kanyang preference. Example, offer 30,000. Yung kanyang preference at least 40,000. So he has the freedom to negotiate na ilagay sa kontrata yung 40,000 instead of 30,000. Or kontrata, 3 months lang, no? So the employee can have the legal means na pwede bang 6 months contract. Or pagbintahan ng supplies, one company and the supplier. So the supplier has the freedom to tell the organization kung yung terms ng service, is it cash, COD, or on account, 50-50, 50% down payment, 50% payable within 6 months. Yung supplier, no? Yung business naman na bumibili, meron din siyang freedom to negotiate. Like, he can ask for a discount or a longer term. Offer ng supplier 6 months lang. And the company, the buyer can have the freedom to extend, like, pwede bang 9 months. Yan yung autonomy, no? Without no intimidation. You have the right to negotiate. Walang fear, walang intimidation na nangyayari. That is autonomy. And number 3, relativity. Let us read the definition of relativity. This characteristic of contract refers to the principle that contracts are binding only on the parties involved in the agreement. Kung sinong pumirma sa kontrata, the buyer and the seller, sila lang yung binding. Or sila yung bound under the law to fulfill or do what is stipulated or written in the contract. Wala nang iba. Right? So this means that the rights and obligations created by contract are relative and apply solely to the individuals or entities or parties to the contract or yung mga sumulat pumirma sa kontrata. The concept ensures that third parties who are not signatories in the contract are generally not bound by its term nor can claim benefits. Ang third party, example, may buyer and seller, tapos merong bangko. So yung third party ng bangko, for example, the bank is the third party, he's not bound to fulfill obligation. Example, no? Ako yung buyer ng bahay, merong seller ng bahay. Right? Ang kontrata dito between me and the seller. Kapag nangutang ko sa bangko ng pambayad dun sa bahay, yung bangko, third party, hindi na sa kasama. Doon sa ibig sabihin, pag ako'y nag-default, hindi pwedeng habulin ng seller ng bahay yung bangko kasi hindi naman siya kasama sa kontrata. Kami lang. Right? Or, he is not bound, third party is not bound, or the third party cannot claim benefits doon sa kontrata. Exception. Sabi natin, pag third party, you cannot claim benefits or you are not bound by the law. Exception and certain exceptions provided by law. The contract create obligations and rights exclusively for those who have entered into the agreement. Outsiders are not directly affected by the contract's term. May mga times din naman na exception to the rule. Ang third party is also involved except in some cases. Example, pag yung Sa insurance, no? Contract of insurance. Ang contract ng insurance between the company and the person who signed or who are paying the premium monthly ng insurance. Kapag yung principal or the person paying the premium died, yung beneficiary ang kukuha. Yung beneficiary third party. So that is an exception to the rule. Okay, number 5, consensuality is the last characteristic of a contract. Consensual. And let us read this one. The consensuality characteristics of contracts emphasizes that a contract is formed and becomes binding through the mere consent of the parties involved. This means that the agreement arises when there is mutual understanding and acceptance of the terms by both parties without the need for any formalities. Consent lang do, yung contract na form through mutual agreement, meeting of minds between the parties. Pag merong acceptance ng terms, example, yung seller, in-accept na yung term ng buyer, yung buyer, in-accept na yung term ng seller, meeting of minds. Yung contract, it is formed by mere consent without formalities. Example, without written, even not in writing. The contract is formed. Otherwise, if it is required by law na dapat in writing or formality yung contract, susundin yun. But in the absence of any provision of the law na dapat nakasulat, meeting of minds is enough, will suffice as the start of the contract. May kontrata na form. Just acceptance or meeting of minds of the parties. So consent, pag saan consensual, consent is the key elements that brings a contract into existence. Kasunduan lang, no? Meeting of minds will form a contract. Okay, so yung mga characteristics ng contract natin. Contracts, and let us go to the next slide. So, this additional explanation sa obligatory characteristic of contract. It is a rule that once the contract is perfected, it shall be obligatory force upon both of the contracting parties. Pag na-perfect the contract, ay pag sabing kontrata ng perfection, meeting of minds, nagkasundo na. During that time, the contract is now enforceable. Pero ang obligation ng parties to enforce fulfillment. Meeting of minds lang, kasunduan pa lang. Consent, pag mayroong consent, the contract is now enforceable. Either parties can now force the fulfillment of the obligations. Quality, the contract must bind both parties, mutual. Both parties are reciprocal, hindi lang isang party yung dapat mag-fulfill, both parties. So the validity or fulfillment of a contract cannot be left to the will of one of the contracting parties. Ibig sabihin yan, parehong parties ay nag-agree. Hindi lang isang party, hindi lang yung seller, hindi lang yung buyer nag-agree, pareho dapat na nag-agree. Pag sinabi natin mutuality, validity or fulfillment may be left to the will of a third person. Those decisions shall not be binding until made known to both the contracting parties. No, pag sabi natin kanina, may exception naman no? Yung third person liable pag parehong parties ay alam. Example, yung bangko, no? Bangko is the third party. Tapos, dapat parehong buyer and seller ang nakakaalam na mayroong third party. Hindi pwedeng isa lang. So, but the presence of a third party should be known to both the contracting parties, the buyer and the seller, para maging valid yung kontrata or para maging enforceable yung kontrata. Okay, so next slide. One of the parties, pag same parties, pwede yung buyer and seller. One of the parties given the right to cancel a contract, not violative of mutuality, because the exercise of that right is fulfillment of the provisions of the contract. Okay, ibig sabihin, pag isang party ay given the right to cancel yung kontrata, sabi natin kanina, Pag sinabing mutuality, parehong parties ay nakakaalam. Pero sa box na to, one of the parties is given the right to cancel a contract, and that is not violative, hindi rin sa violation ng mutuality. Sabihin, pag isang party ay given the right to cancel, example, di ba pagbintahan, may nakalagay doon the seller can cancel at any time. Yan. Hindi sa violation ng mutuality. Because that is a fulfillment of the provision of the contract. Pangalang box natin dito, the unilateral determination and imposition of the increased rates of an interest is violative of the principle of mutuality of contract. Example, nangutang ka sa bangko. Sabi ng bangko, ang interest is 20%. Sabihin, pag nagpunta ka sa bangko ng 100,000, ang interest niya is 20,000. That is 20%. That is agreement. Now, pag yung bangko ay nag-impose ng additional interest na hindi alam nung borrower, that is unilateral. That is a violation of mutuality of contracts. Ibig sabihin, hindi pwede magtaas ng interest ng bangko pang hindi alam ng borrower. Example, pagkasundan 20%. And suddenly, the banks increase the interest to 25%. That is violation of mutuality. So, dapat alam ng borrower na nagtaas ng interest para masabi natin mutual. Hindi pwedeng unilateral. Pag sabi unilateral, isa lang nakakaalam. In a contract which appears to be heavily weighed in favor of one of the parties so as to lead to an unconscionable result. Here's the reason. Pag yung bangko nagtaas ng interest to 25% from 20 to 25% without the knowledge of the borrower, that is in favor of one party only. Hindi pwedeng ganon. You should not enrich yourself at the expense of the other person. That is violation, that is void. Dapat pinapalam sa depositor na mag-increase ng interest rate to 25%. Otherwise, the contract is void. Kasi walang mutuality. Okay, next slide natin. The contracting parties may establish such stipulations, clauses, terms, and conditions as they deem convenient. Itong sinasabi natin autonomy, autonomous characteristic of contract. Pag sabi autonomous, once again, what parties, yung dalawang parehong parties na, pwede silang maglagay ng kung anong gusto nila ilagay, stipulation, clauses, or terms, conditions na gusto nila doon sa kontrata. That is okay, that is allowed, that is autonomy. That is autonomous characteristic of a contract. Walang pipigil siya kung anong gusto niyang ilagay dyan. Tinawag natin siyang autonomy characteristic. Right? Kaya lang, merong limitations ang autonomy. Ito yung mga time na kailan hindi ka pwede maglagay ng agreement or stipulations or conditions or terms na gusto mo. Mga limitations of the principle of autonomy. Stipulation number 1, pag yung stipulations ay contrary to law, contrary to moral, contrary to good customs, contrary to public order, contrary to public policy. Sabihin, pag yung condition or stipulation na gusto mo ilagay ay violation ng law, moral, good customs, public order, hindi yan pinapayagan. Kaya ilagay sa kontrata. It cannot be stipulated in the contract. It cannot be conditioned in the contract pag may violation. Example, gusto mong ilagay dyan na sa kontrata between the employer and the employee, of the employer, gusto mong stipulate dito na ang trabaho mo isang araw ay 10 hours. So hindi pwede kasi that is violation of labor code. Kasi 8 hours lang ang trabaho ng isang employee. Sabi ng employer, gusto mong ilagay sa ating kontrata natin na ang sweldo mo ay payable within 35 days. O again, that is violation of labor code. Sa labor code nakalagay doon dapat 30 days babayaran mo ang sweldo na sa employee. Okay? That is against law. Hindi pwede stipulated sa kontrata. So, sabi ng employer, ang sweldo mo 500. Okay, that is against the minimum wage law. Hindi pwedeng ilagay doon sa kontrata. Okay? or yung buyer ang nagsabi ng buyer, ito ang gusto kong ilagay sa kontrata. Ang bayad ko dapat 50% ay cash, tapos 50% ay payback yung bayaran ng marijuana, box of marijuana, o hindi pwede, dati sa against the law na naman, di ba? So, you're allowed to write conditions or stipulations sa kontrata basta hindi siya violation ng law, good customs, public order, public policy. Number two, limitations of autonomy, weakening the consensual nature of contracts, giving undue advantage to one of the contracting parties. Ibig sabihin nito, pag maagrabyado yung isang party, hindi mo pwedeng i-exercise yung principles of autonomy because it will give you undue advantage. Dapat, pag sinabing parents patria, parehong party are being protected ng kontrata dapat. Hindi pwedeng isa ay maagrabyado or hindi pwedeng mag-give ng undue advantage sa isang party. Pag nangyari yan, that is limitation. Sabihin, hindi mo pwedeng exercise limitation ng autonomy. Okay, so let's go to the next slide natin. Sample. Employment contract between A and B. So, A is the employer, B is the employee. May nakalagay doon, B agreed for period of 5 years after employment with A, B will not do business or employed in similar business as A in the Philippines. Ibig sabihin yan, yung A employer, di ba, at yung B employer, ibig sabihin yan, hindi ka pwede maglagay ng kontrata, hindi ka pwede maglagay sa kontrata na si B, hindi pwede magtrabaho sa ibang tao at kagaya na aking business sa loob ng 5 years. Si B, si B, in-employ ko. And pag mag-resign siya, sabi ko, hindi ka pwede pumasok sa mga kompetensya ko sa loob ng 5 years. Ilalagay sa kontrata natin. Ang tanong, valid? Answer, hindi. Hindi ka pwede maglagay ng ganong stipulation sa kontrata na si B ay hindi pwede magtrabaho sa mga kompetensya ko sa loob ng 5 taon. Bawal yan. Pag kayo ay may nakitang, example, you are now employed later on. Pag may nakita kayong kontratang, nakalagay sa kontratang ganon, hindi siya valid. The contract is void. Sabi ng Supreme Court, that contract is void. That is contrary to public policy. Agreement is clearly one in undue and unreasonable restraint of trade. Yan. That is weakening the other party, weakening the employee, and giving undue advantage to the employers. That is not allowed. That is void. Pag meron kayong tratang na nakitang ganon, later on pag nagtatrabaho na kayo, that is void. Okay, so let's go to the next one. Next slide. General rule. Generally, ito yung pag-usapan natin. Generally, ang kontrata daw should take effect only between parties. Between the two parties na tagalagay sa kontrata. Within the parties, your assigns and heirs. Pag sinabing assign, ito yung mga taong you-assign to be your beneficiary. Pag sinabing heirs, ito yung mga tagapagmana. Yan. So, sa kontrata, ang kontrata will take effect lang between the contracting parties or yung kanyang mga assigns or yung kanyang mga heirs. That is general rule. Pag sabing general rule, may exception. May limitation siya. Limitations. However, with respect to assignees or heirs, the general rule under Article 1311 is not applicable if the rights and obligations arising from the contract are not transmissible or purely personal. Yan. Mayroon kasi mga obligation na hindi pwedeng ilipat or non-transmissible or purely personal. Yan, hindi pwede siyang ilipat. Example, pag ako'y kontrata between 2 persons. O pag ikaw nanalo sa contest, sabi ko, kakantahan kita. Kasi maganda yung boses ko. That is non-transmissible. Hindi sa pwedeng ilipat kasi ako lang may boses na magaling kumanta. Hindi ko sa pwedeng ilipat sa ibang tao. That is personal kasi. That is non-transmissible. Di ba kasing obligation, pwede mong ilipat no? Example, nagkasundo kayo sa pamangkin mo. Sige, pag ikaw nag-graduate pag ikaw ay nakatapos ng high school, ako magpapaaral sa'yo ng college. Kontrata. Okay? Pag di ko na kaya, ina-assign ko yung aking kapatid na in my behalf, siyang magtutuloy. Pag di ko na kaya. That is transmissible. Pwedeng i-assign, no? Pero yung pagkanta na ikaw nag-graduate, ang regalo ko sa'yo, o kakantahan kita, that is non-transmissible. Kasi personal siya, no? Hindi naman lahat ay kaboses ko or hindi naman magandang kumanta. Okay, next slide. Binding on parties. The contract directly affects only the individuals or entities that are part of the agreements. So, kung sino nakalagay sa kontrata, sila lang yung binding. Yan ang una. The binding parties, example, the buyer and the seller are the two contracting parties. So, they are bound by the law to deliver the vehicle or to pay the vehicle. So, sila ang contracting parties dyan. Sila ang number one priority na kontrata. Number 2, ito yung mga assigns o ito yung mga tao or party. If a buyer or seller transfer yung kanyang rights doon sa kontrata or obligations to other person, pwede sa assign sa ibang tao. We call those person as the assignee. Okay, example, pag contract of insurance, ako ay bumili ng insurance plan sa isang insurance company. Insurance company is the seller, ako yung buyer. Nakalagay sa kontrata, no? Kasi in case na may nangyari, I am assigning my benefits to be given to, example, the wife, the children. So yung wife and children, tinatawag na yung mga assigns or assignee. And number 3, ito mga heirs or sa Tagalog, mga tagapagmana, no? In the event of the death of one of the parties, their heirs may assume the obligations and rights under the contract, unless the nature of the contract dictates otherwise. So once again, may mga obligations that cannot be assigned, example, personal services that cannot be inherited. Pero yung mga lupa, mga tangible lupa, bahay, property, pera, those can be inherited. Those can be transferred to the heirs. Pero may mga object that cannot be transferred like personal service. Okay? Nung namatay, sabi na namatay, sige, kontrata tayo. Habang kayo nabubuhay, okay, ako yung magsisilbi sa'yo. Sabi niya, pag one of the party will die, hindi na matutuloy kasi personal service wala na siya, no? Service cannot be done anymore. So personal service cannot be assigned to the heirs. And the last slide for this lesson. Let me see. Ito. This is the last one. In the context of contract of law, the principle that contracts take effect only between parties, they are assigns and heirs. So let us understand this one. Generally, ang contracting parties ay yung buyer or seller, but they can assign the obligations to the assignee or to the heirs. So what we call this one as, it refers to the relativity characteristic by contract. Pag sabing relativity, di ba? It happens only between the contracting parties. This means that obligations and rights established by contract are binding only on the parties who have entered into the contract, as well as their legal successors, the heirs, such as assigns those to whom contractual rights or obligations are transferred, or to the heirs, those persons who inherit rights or obligations in the case of death. Itong paragraph na to, we call this the relativity characteristic of the contract. Pag sa relativity, ang isang contract is binding only between the two parties na nakalagay dun sa kontrata. Or, you can assign the obligation to the heirs or to the assignee in case something happened to the person or to the parties. Okay, so those are the nature of contract, the definitions, the stages, the characteristic contract. So hoping that you guys have gotten something sa ating discussion for today. And since this one is the last slide, I would like to thank you all guys for dropping by and viewing aking video discussion, sharing about contracts, the nature of contracts, and hoping that next time you'll still be viewing or watch my video. And until next time, this has been Dr. Cortez, Doc Rich, signing off, and take care everyone. Bye-bye.